Good morning, everyone, and welcome to this Evershed Sutherland PROPcast. My name's Joe Geen. I'm a professional support lawyer to the real estate practice group here at Evershed Sutherland. I'll be joined in a moment by Steven Thom and Emyr Jones, who will be introducing themselves. Now, our topic today is the Renting Homes Wales Act 2016. This is a bit of legislation that's relevant to anyone who's working with tenanted residential property in Wales, and so often comes up for developers and universities, as well as those in PBSA, purpose-built student accommodation, and BTR, build-to-rent sectors. Not to mention, of course, those financial institutions who are providing lending facilities to organisations who themselves are operating in this space. The main body of the legislation came into force in December 2022. So it's now had a little bit of time to bed in, and it's really quite a good time to reflect on what this has meant for Wales and how things have developed. Now, of course, there is a different regime operating in England, and there's currently legislation which is working its way through the Parliament in Westminster that may bring the Welsh and English regimes slightly closer together. But it's worth bearing in mind that, of course, whilst both countries are moving towards greater regulation in a general sense, they're not necessarily doing it in the same way. So I'm very pleased to welcome Steve and Emyr, who are two experts on this area. Would you like to introduce yourselves?
Hello, everyone. My name's Steven Thom, and I'm a Principal Associate here at Evershed. I am a solicitor specialising in all aspects of residential real estate, particularly regulatory matters affecting landlords and tenants.
Morning, everybody. My name is Emyr Jones. I'm a barrister at Francis Taylor Building. I do a combination of chancery and property work and planning work, and of relevance to today, I was for Welsh Government and still am in the Mitchell case, which is to do with electrical condition reports and fitness for human habitation, which I think we'll probably touch on later.
Well, thank you both for joining us. Now, as I mentioned earlier, the 2016 Act did make some major changes to how residential tenancies in Wales work, and of course the terminology that's used. For example, those living in any dwelling, they're not called tenants or licensees, but they are contract holders. Now, we've only got half an hour, as I mentioned, for today's session. So most of these points we'll pick up as we go along and give a little bit of an explanation as they come up. But we should briefly say at the outset that whilst there are two main forms of occupation contracts that we need to be aware of, those are standard contracts, which are generally granted by private landlords, and secure contracts, which are those which are usually granted by community landlords. Steve and Emyr are going to be focusing on standard contracts for the purposes of today's session, just because we've got limited time. So first things first, occupation contracts, they are a new creature of statute. We're used to thinking about documents which give us rights of occupation as falling into categories such as lease and licenses. But Steve, what's important to know really to start things off when you're looking at the Renting Home Wales Act and occupation contracts? Particularly, are these contracts leases, licenses, or are they something else altogether?
Thanks, Joe. Well, I think it helps to put it in a little bit of context first. So, as you said, the introduction of the Renting Homes Wales Act was a wholesale reform of the short-term letting market in Wales, and the primary aim was to improve the experience of renting from a tenant perspective, making it easier and more secure. So I think the occupation contract regime is best thought of as a mandatory framework that's intended to standardise the terms of residential lettings in Wales. So the thinking goes that by guaranteeing a standard set of rights and obligations, the unfair practices of perhaps a small minority of landlords can be rooted out to improve the rental market as a whole. However, it's important to note that the Act also abolished the assured short hold tenancies that we were familiar with in England and Wales. This was to correct perceived structural issues with the assured short hold tenancy regime, such as the landlord's ability to serve a 2-month notice requiring possession of the property under a no-fault basis using the Section 21 procedure. So, in a sense, this occupation framework is a new type of tenancy per se. Rather, it applies to leases and licenses alike. So long as the lease or license qualifies, the framework will apply and dictate the terms that must appear in the agreement, and it also sets boundaries for the terms that the parties can agree between themselves. So I think that's a long way of saying that occupation contracts do not replace leases or licenses, they regulate them. But I think Emyr probably has a little bit more to say on that point. In terms of what qualifies as an occupation contract, there's a test known as the Section 7 test that sets out all the criteria that must apply to the agreement. So first of all, rent or other consideration is payable under it. Secondly, it is made between a landlord and individual as opposed to a corporate entity. If there's more than one tenant or licensee, it's sufficient that one of them is an individual to bring the agreement within the scope of the legislation. And finally, it confers on the individuals the right to occupy the dwelling as a home. Now note that that's quite a bit wider than under the old assured short-hold tenancy regime, as it doesn't require them to live in the home as their main or principal residence. So with that wider scope, it catches a greater number of agreements, which will include, in certain circumstances, licenses. There are some key exceptions to qualifications. So, for instance, holiday lets, business tenancies, or long leases granted for a term of 21 years or more. And I think as we get started, just to give you an idea of the nuts and bolts of an occupation contract, so they can be either fixed or periodic, and similar to the assured short-hold tenancy regime, a periodic contract automatically arises if contract holder, if they stay in occupation following the end of the fixed term contract. The agreement needs to be documented with a written statement which contains all the terms of the agreement. So similar to your written tenancy or license agreement, which then must be served on the contract holder. And this statement must contain the names of the parties, the key matters, which are essentially particulars such as the address and the rent, whether the contract is fixed term or periodic. And then we have a number of what are known as fundamental terms. So these are mandatory terms that must appear in every occupation contract, and they come in two flavors. So F or F plus. F terms can't be amended. F plus terms can be amended to the benefit of the contract holder. Then we have supplementary terms. So these can be amended or deleted entirely, so long as the amendment or deletion of the term does not conflict with any fundamental terms. And finally, additional terms. These are anything that the parties wish to negotiate between themselves and include within the agreement, but this is always subject to the proviso that it can't conflict with any of the fundamental terms. If there is a conflict, the fundamental terms are going to prevail.
So I suppose what we're seeing there is it's sort of dangerously close in some ways, in that we've got terms we're familiar with, concepts we're familiar with, but actually we're applying them to this whole new regime, and there are these key fundamental differences that really make a difference day to day. So as Steve's saying there, I mean, these new creations, these occupation contracts, they do stand apart in quite a clear way from what we're used to seeing and dealing with. How do you see them from a base principle perspective, and how that might then work its way out and play out on a practical level?
As Steve has given a very good summary of what is a very comprehensive regime and a very long regime, and the Act is long. I think in terms of how I see it from a point of principle, the starting point is the Law Commission published a report in the early 2000s saying we need to reform residential tenancies effectively. And that report was aimed at England and Wales, and it was the Welsh government who took it up. And as you've said, Joe, that there's a bill going through Parliament in England now, which is adopting some of that thinking. And the reason for the Law Commission saying this needs reform is complexity, and saying that landlord and tenant law is notoriously complicated. I've got a quotation here from a case in 1925, which is a good illustration of things in law. They take time to get reformed. And it's from Lord Heward, who says, "It's deplorable that a private individual, and most of all a private individual who lives in a small tenement, should have to make some sort of path through the labyrinth and jungle of these sections and schedules. So that really, the regime is intended to overcome that. It's transparency, fairness, principles really drawn from consumer law. So that's, I think, the lens through which you look at everything in the Act. And as Steve said, it's basically tenant friendly. We traditionally, as lawyers, think of leases and licenses. Licenses still exist, but I think in practice they've been eliminated from Wales unless they're holiday lets or something of that nature. And I think if you look at the Mitchell case, we're wedded to tenancy in that language of landlord and tenant. A contract holder is effectively a tenant. So it's there to be clearer, I think, to the consumer, and the consumer is the tenant, or in Wales now, a contract holder.
Okay, so let's take a little dive into maybe something that's still a little bit of a labyrinth and a jungle, to go back to that quote, because that gives us some of the foundations for occupation contracts and the 2016 Act and really what it was designed to do, going from that Law Commission paper and through the Welsh Government's initiative of it. Now, often with these sorts of residential arrangements, they are shorter term. There might be somebody who takes the arrangement over for a year or something like that. But we do get some that, of course, are granted for a lot longer. People who stay in their flat, their house, whatever it is, for a significantly longer amount of time. Now, given that the Act brought in such fundamental change to how residential law works in Wales, it's worth having a little think about how the change in law affected those existing arrangements, be they leases or licenses, that were already in place. And then when December 2022 came around, were subjected to this new area of law, these new sweeping changes. Steve, what does that look like for you when you're analysing those things that were already in place and now have to exist in the new world of the 2016 Act?
So yes, I mean, the position was that as of 1st of December 2022, if you had a lease or a license that was already in place and it met the Section 7 qualification requirements for an occupation contract, it would automatically convert over into an occupation contract. There were some excluded leases and licenses that wouldn't be included in that, but that was the basic position. The parties could also, in certain circumstances, for an agreement that didn't qualify, they could actually serve notice to bring it within the occupation contract regime. But I think the final date for service of such notices was back from 1st of February 2023. So we shouldn't see any more of those. But I think that the key issue from a transactional point of view is there's going to be an obligation on the landlord to serve a written statement of this new agreement. Now, trying to compile a written statement from a pre-existing license or lease that likely wasn't drafted with a view to complying with the fundamental terms, etc., of the Renting Homes Wales Act. So that's going to be a tricky exercise in and of itself, and making sure that it's done correctly. But there's certainly a lot of scope for argument. I mean, Emyr, what's your take on that?
Yeah, I suppose you've got two categories. You've got institutional landlords or large-scale landlords who did their best, I think, to draft new contracts reflecting the new regime. So they're in one category, and they would need the tenant, who's now become a contract holder, to sign that. And then you've got the second category of people who just carry on as they were. And as you've said, Steve, the fundamental provisions apply. The supplemental provisions apply unless they're inconsistent. I think that's probably a fertile source of debate and possible dispute. In a particular case, people, especially if they've got bespoke old contract tenancies, do the supplemental terms apply or not? So there's scope for what is the inconsistency in that, and so on and so forth. And I think, obviously, that's quite a long time ago now, December 22. But what occurs to me is that when the new regime came in, if landlords weren't on top of it, things might be carrying on without any difficulty, even though they've not, had a new contract drawn up. But things could come to light later down the line in terms of, say, rental arrears. Contract holder says, well, I've always paid my rent, but I'm in difficulties now. Looking back historically, did they comply with everything they were supposed to comply with back in the day? And then an argument that maybe I'm not in arrears after all. So, the transition period is basically over, but things could crop up. More likely, I would have thought, with smaller scale landlords. But
so I suppose we've got something really interesting there, haven't we? Because we've got the historic context where you have perhaps older drafting, older terms, things that were built within a different context, and now transitioning into this new area of law. And I'd like to sort of build on that a little bit and see how that plays out now going forward, because I don't think we're necessarily away from that. Although we've talked about transparency, certainty, there are going to be elements that persist. So we're looking at something that is sort of movable, where you start from the original agreement, the agreement that the parties have drafted between themselves, whether that was pre the Act coming into force or post. But of course, then you've got the statutory intervention, and you're left with something that's between the two and perhaps being pulled in both directions. And whilst we have those almost fixing points that Steve mentioned earlier, the fundamental terms that really pervade the regime and occupation contracts and will always apply, what we're also seeing is the publishing of model contracts, which have been developed there to really help landlords, to help contract holders navigate this new law. Steve, you're, I suppose, at the sharp end of some of the drafting, working with these model contracts and occupation contracts. And Emyr, of course, you've been looking at this law, and you're the one who then has to unpick it, interpret it, and see how that plays out perhaps sometime down the line where things haven't gone exactly as the parties would have intended. I'm keen to hear from both of you on this in terms of how you make this tug of war really work. Steve, would you like to go first on that point?
Sure, thanks, Joe. So as you say, the Welsh Government's prepared model written statements for occupation contracts, both fixed term and periodic versions. And this really assists landlords in complying with the complexities of the new regime. The model contracts are helpful. However, of course, it's a very challenging task for the Welsh Government to draft a suite of one-size-fits-all documents, considering the myriad of letting circumstances. So as the cover information on the contracts indicates, they're not going to fit all circumstances. They're intended to be adapted as necessary. But even so, they are a useful guide and a starting point. It certainly assisted me when I was first getting to grips with this area. When carrying out amendments, if you're going to depart from the model in any way, it can become a really painstaking drafting exercise, particularly if there's a large number of additional terms or substantial amendments to the supplemental terms, as each change needs to be considered to ensure that it does not conflict with the fundamental terms. So if there's a conflict with the fundamental terms, as I said before, the fundamental term is going to prevail, and that could mean the document at best doesn't reflect the parties' intentions. So ultimately, if a proposed agreement is outside of the ordinary or the parties are in any doubt, they really need to be taking independent legal advice to ensure the draft document fits circumstances and is compliant with the legislation. It's actually worth highlighting a point, the mechanism for periodic contracts arising at the end of a fixed term contract. It's slightly different from the old short hold tenancy regime. So if the contract holder remains in occupation at the end of the fixed term, a new periodic contract arises automatically. The fundamental and supplementary provisions applicable to periodic contracts will apply. The legislation says without modification. Otherwise, the new contract has the same terms as the fixed term contract had. My thinking is that this may cause some unforeseen issues if you can't roll over, say, some amendments to the supplementary terms. that you may have made in the fixed term contract. However, I think the position is a little bit unclear, because there's the legislation also has provision for you to specify the terms of periodic contract that arises. And in doing so, the question is, well, can we override that without modification? Obviously not in relation to the fundamental terms, but in relation to the supplementary terms. So I think we probably need some case law to clear that element up. But it does have if you specify terms, it does have the benefit of removing an obligation on the landlord to serve a written statement, which I think when the periodic contract arises, it triggers an obligation for the landlord to serve a written statement of that periodic contract. Now that's going to catch a lot of landlords out, I think, whose tenancy has been running for a couple of years, say. So it's quite an admin burden. So ensuring that you specify the terms of that periodic contract would remove this obligation and reduce the admin burden somewhat.
So I suppose talking there about how we could do with a bit of case law maybe to clear up some of this, I think we've got the perfect guest to speak to that point really, and how that might play out. Emyr, what's your thoughts on this?
Yeah, I agree with Steve. I think it's once you depart from the model contracts, and as Steve says, in some cases, that's sensible from both the point of view of the landlord and the contract holder, because it is although they're very long, it is a bit of a straitjacket, and you may want to change it. You know, if you put something in which is inconsistent with a fundamental provision, well, that's unhelpful, but it's straightforward because the fundamental provision trumps whatever's in the written contract. I think what's trickier is, as Steve said, once you start modifying it, there's a question of what is are the supplemental terms or supplementary provisions, are they modified, yes or no? Now, if you have a term which says, for example, in the Mitchell case, Regulation 11 says, if your property is not fit for human habitation, you're not required to pay rent. So that's a supplementary provision, which will apply unless it's been modified. Now, if you have a contract which says, Regulation 11 does not apply, then that's fine. But if you have something which is less clear cut, then you can see arguments about, well, has that supplementary provision been modified by implication? If you look at the entirety of the agreement, how does it work? Is it coherent with that supplementary provision? So you can have lots of debates there. And as Steve says, if you are going to change terms, you need to think about that, and you probably need to get independent legal advice. But where there is ambiguity, I would come back to the overarching theme, which is it's really consumer law. The supplementary provisions are mostly there to help contract holders, not all of them. Some of them are there to help landlords. But to bear that in mind, we don't have the case law yet. We've got case law in terms of cases where model contracts have been applied, but that's slightly different, and that's the Mitchell case.
So we've got there the idea of, again, making all these things marry, and how important it is to look at these occupation contracts in detail, seeing perhaps where changes can be made, where they can't. Now, we could talk for a long time about the different administrative provisions within there. We've touched on those, and then how written statements need to be served and that sort of thing. And also the idea of the small tweaks that could possibly be made and the challenges that might be faced by a landlord or a contract holder throughout. But I'd like to jump ahead really now towards the end point, because this will be critical for many, certainly landlords out there. And as we're sort of approaching the end of this PROPcast, I think it's quite appropriate to talk about, well, what happens when you are coming towards the end of an occupation contract, and how can that be managed? Because, of course, getting the property back is often as important as handing it over in the first place from a landlord's perspective. And, of course, occupation contract holders, they want certainty. They want to know exactly where they stand, if at all possible. So Are there particular difficulties that maybe might crop up when you're looking to bring these to an end, and how do you plan for them? Steve, do you want to talk to that point first?
Sure. Well, I mean, in short, it is more tenant friendly. So whilst so-called no-fault evictions are still possible, you're looking at, in general, a 6-month notice period, and that's when you've got a periodic occupation contract. If you've got a fixed term, the tenant's going to be entitled to remain until the end of the fixed term. Break clauses are possible, but there's a break notice can't be served for the first 18 months. So you're really looking at quite a, not just a year tenancy, you're looking at minimum 2 years really, if you want to start including break clauses. So perhaps from a landlord perspective, the utility of such clauses is somewhat diminished. And then looking at grounds for eviction if there's cause, well, it's not too, there are a number of differences, but something that a bit more familiar to the for landlords that have been dealing with the Section 8 procedure for evicting tenants with grounds, which I'm sure Emyr could speak to a little bit more than I can.
Yeah, it's Steve, I think I highlighted the first big point. It's 6 months notice period. That didn't have to be in the Act. Initially, it was going to be 2 months, and then a policy decision was made to increase it to 6 months. I think other potential challenges for landlords and issues for the court to think about are, breaches of statutory requirements. So if you haven't got an ECR, if you haven't got a gas certificate, if you haven't put a smoke alarm in, etc., you can serve a notice, but it's not valid. So that's one potential pitfall for landlords. The other one is Section 217, which says basically there are certain absolute grounds, one of which is you've given the 6 months notice. But if the court thinks that it's a retaliatory action, so you're doing it as landlord because there's been a complaint of disrepair, or that the dwelling is not fit for human habitation, the absolute ground becomes a discretionary ground. And going back to the overarching aim to protect the consumer, it's early days, but you can guess that the court may be very eager to say, well, we're going to exercise our discretion here in favour of the contract holder, not in favour of the landlord.
And I think that's probably quite a good note to bring us to an end, because what we've seen there is we've seen what was created at the outset and how that's influenced the decisions that are being taken and the occupation contracts that are being put in place. But the theme that goes throughout is the tenant-friendly element, or the contract holder-friendly elements, I should say, and the fact that the courts will likely be looking to realise that through the case law. So that brings us to the end of this Evershed Sutherland PROPcast. All that's left to say is a big thank you to Steven Thom from Evershed Sutherland and Emyr Jones from Francis Taylor Building. And to everyone listening, thank you very much.
Thanks, everyone.
Cheerio.